Hello and welcome back to the channel. Today we actually have some news in the Vallow Daybell case. It's kind of curious, so let's get into it. The first thing we have is a motion filed today with the court by John Pryor, who's Chad Daybell's attorney. This is a motion to dismiss the case. Right. Good luck with that. Let me read through the motion and then we'll discuss what it says. Comes now the above-named defendant, Chad Guy Daybell, by and through his attorney of record, John Pryor, and moves this honorable court for an order dismissing the above-noted case pursuant to Idaho Rule of Criminal Procedure 12b. The grounds of motion. Said motion is based upon the lack of sufficient evidence to continue to bind defendant over upon all four charges as presented to the court at the preliminary hearing on August 3rd and August 4th of 2020. Further, the charges are not supported by the evidence and duplicative as allegations against the defendant. Further, the prosecution has yet to present evidence to support when the alleged acts is supposedly to have taken place, and if the defendant acted in any manner to support those allegations. The prosecution made assertions in his complaint and information that are vague and overly broad. Those assertions violate the defendant's U.S. and Idaho constitutional rights to be fairly notified and appraised of when, how, and what he is accused of doing. Defendant reserves the right to additional defenses to this motion once the state has provided all the discovery they are required to provide to the defense. Defendant, through his counsel, moves this honorable court for an order dismissing the charges. Defense's counsel has submitted a request to extend time to hear this motion and respectfully request that the court set time for the motion to dismiss after the preliminary hearing transcript has been provided to defense counsel and an adequate amount of time is allowed for the submission of a brief in this matter. Dated August 27th today. Alright, let's unpack this. There's not too much here, but what is here is, in my opinion, and I'm not a lawyer, but I think it's absolutely ridiculous. The first thing he says, there's a lack of sufficient evidence to continue to bind the defendant over, blah, blah, blah. That's what the preliminary hearing was for. Judge Edens ruled that there was certainly sufficient evidence to continue to bind the defendant over upon all four charges. That's what we had the hearing for. That was the ruling. Tough. Okay? The second thing he goes on to say is that the charges are not supported by the evidence and duplicative as allegations against the defendant. Baloney. First, they are supported by the evidence, and as far as the duplicative nature of them, that's complete baloney, okay? Because there are two children, so there are two charges. But there are two different charges. One is the concealment and destruction of evidence. So it's the allegation that Chad himself concealed or destroyed the evidence. The second set of charges are the conspiracy charges. He was part of a conspiracy, a plot, a plan with other people to conceal and destroy this evidence. And there are two charges for that, one for each child. So that's why he's got four charges. They're not duplicative at all. And Pryor, maybe he doesn't do math so much. I don't know. But I don't think he has even the remote grounds at all for this motion. So nice try. We'll see what the judge says. He then goes on to state that the prosecution has yet to present evidence to support when the alleged acts is supposedly to have taken place. Number one, I have some grammatical pet peeves. This is one of them. The alleged acts are supposedly to have taken place. Acts is plural. That is the focus of that part of the sentence. Therefore, is should be are. But that's just me being crabby. But he says that the prosecution hasn't presented evidence to support that. I think he has. I read the probable cause affidavits. We know the exact day that Tylee's remains were buried in Chad's yard. We know the exact day that JJ's remains were buried in Chad's yard. That is when these acts supposedly took place. I don't know why John Pryor doesn't understand that. Maybe I should write him a little note and say, here, you missed this part. Highlight the lines in the probable cause affidavit that state those exact dates. So he's just being fussy. I think what he's doing here is simply just a defense lawyer doing defense lawyer things. So whatever, it's fine. I'm not really even concerned about this because this seems just like, oh, I should have filed this back before the preliminary hearing and I forgot. Oops, let me do it now. It's like grasping at straws, throwing a Hail Mary. I don't imagine that Judge Boyce is going to read this and be like, oh, you're absolutely correct. Let me dismiss all the charges. Right. No, it's not going to happen. So nobody panic. It's just John Pryor doing John Pryor stuff. As far as the information being vague and overly broad, again, I disagree. The probable cause affidavit was very specific. Dates and times are included down to the minute, right? We know by the minute when Alex was certainly in Chad's yard. We know the exact minute that Chad texted his wife, Tammy, to tell her about what was happening in the yard. So, baloney. It's all just baloney. Now, he does say here the defendant reserves the right to additional defenses in the future. Yeah, whatever. And the last thing he's asking for is, in this next motion over here, I'll read it to you real quick. It said, "It is hereby ordered that a transcript of the preliminary hearing in this matter shall be prepared and produced. The defendant shall incur the cost of production and preparation of the preliminary transcript at his expense. Said transcript shall be prepared and submitted to the defense's counsel no later than blah, blah, blah." But he's also asking for more time before they have the hearing about this motion so he can review the transcript and all of that stuff. So this, we'll hear about this eventually, probably in a 30 to 60 days, something like that. But it's nothing to worry about. I don't think it's a big deal. In fact, in a way, you could say that this is probably a good thing because we're getting this out of the way now, so less chances later on for mistrial or ineffective assistance of counsel, something like that. John Pryor is doing what he's supposed to be doing. It's annoying. You see a motion to dismiss, and of course there's a knee-jerk reaction of, no. But let's not worry. I don't think this is going to happen at all. But good luck, John Pryor. Please have somebody proofread your motions before you submit them to the court. And, I can answer these questions for you if you want. Give me a call. Save the state some money. So there you go. That's all that's happening today so far. If anything else comes up, there'll be another video. So stay tuned to the channel. Also, earlier today, I put up a video about how to use Discord. A lot of people have been joining our Discord and weren't sure how to use it. So check that out and come on over and say hello. So stay tuned. I'll keep you up to date. And until next time, take care out there.